The Florida Supreme Court upholds the act. Petitioners arrive at the Supreme Court, U.S. Supreme Court, claiming not actually that the statute is a taking, and not actually that the action of the executive in dumping all this new sand and having the beach extend, not that that was a taking, but rather that the judicial decision upholding the act was a taking. So they're actually complaining that the thing that the Florida Supreme Court did, the opinion of the Florida Supreme Court, is itself a taking. The court grants cert. The court grants cert for this reason. So the court grants cert to take a crack at the interesting question of judicial takings. Is that a theoretically viable kind of takings claim? A judge took my property. A judge took my property by writing an opinion. Now, it's a real interesting question. I think it's interesting for people here and Federalist Society types. On the one hand, if you're a believer in property rights, you might think, well, if I'm a believer in property rights, I sure don't want state judges to be able to sport away my property rights with radical changes in state property law. So conservatives might like that idea. On the other hand, though, Federalist Society types might think, there's something odd about the Supreme Court second-guessing a state court on questions of state law. So something a little bit odd about the Supreme Court reading a Florida Supreme Court opinion and saying, no, they don't have Florida law right, or they've changed Florida law too quickly or something. So there's some kind of odd about that. And that, I think, is what the court is wanting to grapple with, this kind of rich, interesting issue about judicial takings. But I'm not sure this is a good case for that question, actually. It seems to me that this is really actually a question about whether this Florida statute was a taking. And it's just kind of a quirk of the pleadings. I think that they just filed the cert petition saying this raises this question. We hereby claim this opinion was a judicial taking. And, I actually think some Supreme Court clerks were fooled by that. But to me, this doesn't quite actually tee up that question. And it wouldn't surprise me if this case goes away somehow. If the court either doesn't decide it or decides it on some very narrow technical grounds. But I don't think you're going to get the real clean holding about judicial takings that you might be hoping for in this case. But you can, tell me that I'm wrong in questions and answers. I'd love to hear that. Okay, third, Buono v. Kempthorne. This case I like a lot. So 74 years ago, the veterans of foreign wars erected atop Sunrise Rock in the Mojave National Preserve a memorial to veterans who died in World War I. And the memorial is a big cross. It's a big cross in the middle of the national park. There's no indication that the National Park Service ever approved of this or permitted it. They just apparently just went out and built it, at least as far as anyone can tell from the record. And it's been there for 74 years. It's been there for 74 years. Congress, somebody complained ultimately, and a district court said that this violated the Establishment Clause. And so then Congress enacted this interesting legislation. Congress said, well, okay, so that's an Establishment Clause violation, having this cross, and so here's what we're going to do to fix it. We will give the 1 acre parcel of land on which the memorial sits to the veterans of foreign wars in exchange for a similarly sized parcel somewhere else that they can give to us. It'll be like a trade, and but there'll be a condition that the veterans of foreign wars have to maintain a memorial on this 1 acre parcel. Now, crucially, it doesn't say this memorial. It doesn't have to be this memorial. It doesn't say that it has to be a cross, but they have to maintain a memorial. Presumably it may turn out to be this memorial. Okay. So this is kind of an interesting case because for Federalist Society types, this story and the facts on the ground formally look fine. Right? Formally, what is going on is fine. We have some private land with a cross on it, and we have some public land around it. As a formalist, if you're going to try and look for a moment when Congress violated the Establishment Clause, it's just hard to say that giving a piece of land to this private entity and telling them they have to maintain some sort of war memorial on it, seems odd to say that's a violation, that a giving of the land is a violation of the Establishment Clause. So that's, so I guess on the face of the statute and on the face of the facts on the ground, it looks like there's no problem here. But though, if you want to scratch just a little bit beneath the surface, it really looks a lot like what Congress wants, is a big cross right in the middle of this national park, right? So that's what's at issue in this case. And, I think the Supreme Court is probably going to say that what Congress has done here is fine. But I'm really not sure. I'm not sure how this one's going to come out. I think that's what they're going to say. I think it'll probably be 5-4, but I don't know. One thought is, I think the big trick in these cases about whether Congress is endorsing a religion is whether the speech looks like government speech or not. So I'm a little surprised, actually, that the court hasn't focused on the idea of posting signs and things. So just putting up signs at the edge of the 1 acre plot saying, this beyond here is private land over which we have no control. I mean, I would sort of think that the problem would be greatly diminished if you just knew, looking at it, that this little parcel was private land. I think that part of the problem is you can't tell. So I myself would think putting up a sign wouldn't be a bad idea. Okay. That's it? Yes, okay. And finally, the case I think you all probably are most excited about, U.S. v. Stevens. So this one's going to be of greatest interest to the press, I think, first of all, because it concerns freedom of speech, and second of all, because it has such lurid facts. So it came to Congress's attention that some people get sexual pleasure they have a particularly perverse and disturbing fetish, and the fetish is watching women crush small animals with their high-heeled shoes. So stepping on and crushing little animals with their high-heeled shoes. Congress was horrified by this thought, obviously. But apparently there's a thriving market for videos of such acts, apparently. So Congress, horrified by this, passes a statute ostensibly to ban such videos, but the statute goes a good bit further. Whoever knowingly creates, sells, or possesses a depiction of animal cruelty with the intention of placing that depiction in interstate or foreign commerce for commercial gain shall be fined under this title or imprisoned not more than 5 years or both. So this is a free speech case. The U.S. is essentially asking the court to create a new category of speech that is unprotected by the First Amendment. So speech that depicts animal cruelty. They're wanting to say, as a category, this speech gets no First Amendment protections, just simply not within the ambit of the First Amendment at all. The U.S. has not the court has not created a new category like that in more than 25 years. So that was New York v. Ferber, in which they said child pornography was such a category. And so this case poses the question, shall we create a new category? Is this kind of like child pornography? Should we extend that principle? I think it's real unlikely that the court is going to create a new category of speech that's unprotected, no matter how horrified they are by it, I suspect. I'll just make one last point about this. The government's brief in this case is kind of interesting. The government wants to describe wants to construe the statute really narrowly, because the more narrow the statute, the less speech it covers, and so the more likely it is to be sustained, right, to be upheld. So it plays a couple little rhetorical tricks in order to try to make the statute more narrow. One is it says that the statute only covers illegal acts. But it's not really true. The statute actually covers acts that are illegal in the state in which you're selling or possessing the thing, even if they were legal where the video was shot. So, for example, in theory, you could shoot video of bullfighting in Spain, right? But then if you brought it here to the U.S., to a state where bullfighting is illegal and sold that would count.